Now recording. So what I wanted to do today was to really do a quick run through on the dissolution with children packet, which is the only packet that is complete and ready to use. And when I say packet, that's sort of a figure of speech because it isn't set up anywhere as a complete packet. Before we get into the actual forms themselves, I wanted to make a couple notes or a couple comments on how they're set up. What you see on your screen is a sort of a graphic representation of how the forms are to be used, and it is a loose representation of how we're going to go through them. But if you've looked at them at all, or you're looking at your screen now, one of the things that you'll see is these forms have a numbering system, and they're all numbered with MP and then a number. And just so everybody is clear, MP stands for marriage and parenting. That's what the MP comes from. And then the numbers, the 100 whatever, or 300 whatever, or 400 whatever, signify what kind of a document the form is. As an example, the very first one you'll see under step 1 on your screen, it says petition, MP 113. All of the MP 100 documents are petitions. MP 113 is the petition for dissolution with children packet. And all of the MP 200 documents, which you don't see any of in the graphical representation because it doesn't include that, but we're going to talk about it. All of the MP 200 documents are responses. Likewise, MP 300 is parenting plan documents and attachments. MP 400 is service documents, and sort of so on down the line. And I'm going to switch screens here super quick because I want to show you what you should see now on your screen is actually a list of the documents that are in the dissolution with children packet. And you can see MP 400 are service documents, 500 are financial documents, 600 are optional forms, that includes the mediation forms, 700 series are the decree and hearing documents. So that's the numbering system, how to share with, how to logically put the documents in some sort of an order, whether they're dissolution with children or parenting plan or just dissolution documents, was something that the forms committee struggled with, and we came up with this numbering system that we think works pretty well. In the future, you'll see some guardianship documents come out. They will not be MP, excuse me, MP forms. They will be GM for guardianship of a minor forms. So hopefully there's a logic, and once people get used to looking at how the forms are set up, it'll be easier to figure out, oh, I need a petition, that's going to be an MP document. So from here, there's a couple things that I want to point out. One is we still don't quite have all of the documents on the law library website the way we want them. As an example, if you wanted to find the documents that we're talking about, and I'm actually going to be pulling them up from the law library website, if you go to the forms page on the law library website, there's a link here that says Pilot Project 2016 Revised Dissolution and Parenting Plan Forms. And if we go into that, this is where I'm going to be pulling the forms from. However, I realized just today that we don't have one form up that we need up, and that is the instructions. So I'm not going to spend very much time on the instruction packet, but I'll talk to Kay later, and we'll make sure it gets up there. just a quick note that the instruction packet, and there'll be an instruction packet for dissolution, joint dissolution, parenting plan, no dissolution. Each packet will have its own instruction form. But the instruction forms are laid out fairly logically, and within the instructions, there's a list of forms that you need for each step in the process. And it refers to the forms by name and by number, so that if somebody is going through and trying to make sure they have all of the documents that they need, they've got a convenient list. It should be easy to find what forms an individual might need. So I'm showing you one form that we don't have on the State Law Library website yet, and it's the instruction packet. So let me put that away. And let's start out with the instructions, or not the instructions. Let's start out with the petition form. So we're looking for a petition. We're looking for the petition for dissolution with a parenting plan with children. And in here we can see that there's the petition, and then there are possible petition attachments. And I'm going to pull up the petition, which is the only one I actually preloaded, so I didn't have to get it off of the site. The first thing that you'd notice if you're comparing this to the existing forms is it does look a little bit different. If you've never looked at this before, you'll see that rather than saying petitioner pro se, it says appearing without a lawyer. And that is, I think, a significant piece of how these forms were done. We tried very hard to make them very easy to read, user-friendly, and convenient, I guess I would say. So one thing I would point out real quickly is much of the material that's in the petition obviously is quite similar to what's in the existing forms, although in a different format. The one thing that is significantly different is once we get through some basic information, we get into listing out children of the marriage, for example. And a note, here's the place where folks can list out their children, but then there's a checkbox down below that says we have more children, and it instructs the person, hey, go get this other form, the MP 113B, and paperclip it to this. Fill it out and paperclip it to this. And I will tell you that the MP 113B is quite simply a sheet with a list like this on it. In fact, let's go pull one up real quickly so that we can see exactly what it looks like. And here it is. It is set up to be an attachment, and you could have a whole slew of kids and only need the one sheet. So that's what the MP 113B looks like, simply a place to list additional children. Going back to the petition, oops, those are the instructions. We don't want those. We want the actual form. There are some other notes I want to make here. One of them is that there's a place to list other people who might be involved in the children's lives. But significantly here is a note. It says, send form MP 407 to everyone listed. So these are other people who might have a claim of custody on the children. And quickly, again, I want to go find that MP 407 form because it is an interesting and different form. It is designed to be sent to a grandparent or a substitute caregiver to say, hey, there's a parenting plan action about these kids and you've been taking care of these kids, so you get notice of this. And it's called a notice to persons not named in case. And it simply says, hey, parenting case has been filed about these kids. You're getting notice under this statute, and you're getting notice because, and then it says you don't have to do anything, but if you want to do something and you don't know what to do, here's some places you can go to find out what your rights might be, what you can do. And the idea here is to make sure that someone who's been involved in a child's life as a caregiver doesn't get left out of the parenting plan unnecessarily. So that is a significant change from the prior version of the form, in that the petitioner, and actually we'll see this is mentioned in the response as well, that both the petitioner and respondent are told if there's someone else who's been a caregiver, you need to notify them. And this is how you do it. The current version says you need to notify people, but it doesn't really give you any kind of indication of how you do that. So back to our petition, and there's a couple other things I want to point out. The next one is in section 12. It says, hey, court, I want you to adopt my proposed parenting plan. This is a document I'm filing separately, and it includes the following things. We're going to take a quick digression and go look at the parenting plan form because it's kind of cool. And how do we do that? Well, we go back to our pilot project documents. And by the way, you may be wondering, okay, these are posted as pilot project documents. How are they going to be posted when they become the official versions of the forms? And they'll be posted like this in the same format, except not as a pilot project. So we're going to take a look at the parenting plan document, parenting plan form real quick. We want to look at the proposed parenting plan. But again, notice there are several attachments that can be used, some of which, well, I guess one of which is optional, the 300C, limited parenting time. But the others include the schedules. So the schedules are designed as attachments that hang off the main parenting plan document, which we're going to pop up here and take a look at. Again, this is a parenting plan document, but the same parenting plan form is designed to be used whether it is in a parenting plan only case or whether it's in a dissolution with children case. And so either way, we'd be using the MP 300. So as a result, it can be a little bit confusing here, but the petitioner is going to, when they first file it, check off petitioner's proposed parenting plan, assuming it's going to be a contested case and it's not a joint petition. But if it was a joint petition for a parenting plan, it would be the agreed proposed parenting plan that they would be filing first. And again, we have checkboxes to specify who's who in using the parenting plan. Fairly standard stuff. We've got objectives for the parenting plan, and then parents' information, children's information. Here I want to point out, if there are additional children, that requires using the MP 113B, the additional children document. So there is a single form that you use possibly multiple times if you have additional children, or when we get to the financial documents, additional accounts. The idea is there's one form for extra whatever, and you use it wherever it's going to be used. Notice, again, as I mentioned, we haven't hit a schedule, but we do try and provide for the idea that where there's more than one child, the parents may want to have different schedules for each child, especially where the children are significantly different in age. And so that's one of the first selections is we're going to use the same schedule for all the kids, or we're going to use a different schedule, and it's a good idea to have different schedules for each of the kids because, they put in a because, and then again they use the same schedule form, and I'll pull that up in just a second. But again, an option to do that with holidays and vacations, so we can, see, are they all going to be together, or are they going to be different? How are they going to be different? And let me just real quick pop over and let's take a look at the standard parenting time schedule. This is the MP 300A. And, this has to match. Is this going to be for everybody, or is it just going to be for a particular child? Again, we're choosing, this is mother's, father's parenting time. This is how it's going to work. And then we have options for, I guess what I would call the right of first refusal with childcare, transportation. This is sort of the how are we going to get the kids to each other for our parenting time. So pretty simple form on its own, and that's one of the things that was part of how these forms were designed, is that they're broken down. If you're keeping track, then if you're keeping track of the number of forms that there are, the answer is there are going to be way more individual forms in this packet than there were in the current version, but each one is shorter and should be easier to deal with as an individual form. So let me put that away, and let's go back to the petition again real quick. And somebody pointed out, who pointed out in the chat box? I got it. Rob pointed out that in the parties section, I think actually on the parenting plan is what he's talking about. It said, or actually no, it must be on this one. In the petition for dissolution, it says in the marriage of, and that's true because there's a different petition for each packet. So if we were going to talk about the petition for a parenting plan, in fact, let's go look at it. The petition for a parenting plan, this is where I hope it's live, it's a separate, different petition. So each kind of action has a different petition. So we don't need to have a checkbox because we have a separate petition for a parenting plan or a separate joint petition. But the parenting plan itself is going to be the same form, whichever petition it goes with. Okay, back to the petition for dissolution. I pull up the wrong one? No. So then we have the option for supervised or limited parenting time. And again, we're referred to an attachment, which is the MP300C. But here we can see the options are no supervised or limited visitation necessary, or it's necessary because, and there has to have a reason, and then do the MP300C. And again, if we go back to those parenting plan documents, and look at the limited parenting time form real quick. It again appears as an attachment. Does this apply to all of each of the children or just specific children? And then it's got limitations. What might these limitations be? Well, whatever the normal limitations are, but I can certainly imagine a scenario where you have, say, a newborn and someone says, we're going to just do our youngest child, and they check it off and say, little Bobby Doe, as the child this applies to, and say, you know, it's appropriate that the father's parenting time be limited in the following way. Child is a newborn and can't be away from the mother who is breastfeeding for more than so many hours at a time. May also be because someone's a bad actor. Maybe they have an addiction and they aren't safe to be with the child unsupervised. Whatever the reason, you can specify it on the attachment, specify it on the parenting plan form, and let the judge know why that's appropriate. Standard, let's see, standard kind of how's travel going to work things. We added in a section having to do with passports. And remember, we're still in the parenting plan because that's come up a fair amount recently. You have to have something that says a parent can obtain a passport or the State Department won't let you get one unless both parents consent. So that's why that's in there. One of the things that a lot of people had a high degree of anxiety about was the section in the existing plan that says designation of custodian. And people looked at that and said, well, I want to be designated custodian, or it's not fair that I'm not designated custodian, or, well, I don't want the other person to be designated custodian. And they didn't realize that the only reason that's in there is there are some state and federal benefit programs that require a designation of custodian. The term custodian doesn't really appear in the Montana family law statutes. It's only for who's going to have the Medicaid card, who's entitled to count the child in their household for food stamps, those kinds of things. And so rather than have a section that's headed designation of custodian and freak people out, we changed the name to state and federal benefit programs and explain some state and federal benefit programs require one parent to be designated custodian. This doesn't affect our parenting rights or responsibility. It only reflects which parent may include the children when they apply for benefits. There we go. Little explanation, and then for the purposes of state and federal benefit programs that require designation, the mother or father is designated custodian, or they can come up with something else if they want to. But that section took a little time to try and come up with a way to get people to freak out less. Designation of the child for income tax purposes, lets people know in addition to doing this, you have to fill out IRS forms to claim the kids as dependents, and the parents get to choose who's going to do that. Fairly standard stuff, a little bit reorganized with co-parenting guidelines, a couple of choices worked in there, not too different from what already exists. Little different setup in terms of decision-making choices. Lets people know in terms of emergency medical care or emergency decisions, whoever's got the kids makes that decision. And then day-to-day care and control decisions, options to choose from, who gets to make them, fairly basic options. Again, there's some room for somebody to specify a different setup if they want. Access to information follows the statute. Access to each other's information for the purpose follows the statute. And I want to skip down to the actual child support calculation options, because there's some different options here, and these options were set up in part because of feedback we got from judges on early drafts of the forms. So, the first thing is, what's the child support amount, and then what's that based on? And the petitioner or whoever is proposing the parenting plan, using the form to propose one, needs to make a choice. So, why is this amount right? Well, it's consistent with the final Child Support Enforcement Division order signed by the administrative law judge. That's probably what the judges like most, is when we got those. But there's a box to check and instructions for how you attach that to the parenting plan. Or it's consistent with a child support calculation prepared by somebody else. Attach that calculation. Or it's not consistent with a child support calculation prepared by anybody, but it's in the best interest of the child because they can write it in, but they still have to attach whatever the calculation was that was prepared. And finally, there's an option for somebody to say, I don't have a child support calculation, but I have contacted CSED. My CSED case number is, I will file the order that they submit when I request a hearing on this case. So there isn't a real option for, we didn't do a child support calculation. There are options for, there's the option for, we don't have one yet, but we're getting CSED to do it. And then just fairly similar options for how payments are going to be made. Options for when child support is going to terminate, but the medical support stuff, which is again pretty similar to what already what the current forms have. This next section, section 23, is another one that was put in based on some judicial feedback, and it has to do with, if the parenting plan is going to be changed, what are we going to do? And it's right here. It says we're going to do mediation, or there's been some reason to suspect domestic violence. No mediation is appropriate. We just get to go right back to the judge. Again, some guidance on modification. The court can only modify this agreement if, one, we both agree, or two, there's a substantial change in circumstances. Trying to minimize the number of times that people want to get back in front of the judge to change a parenting plan. Let them know you've got to have some basis to do it. Okay. I got to shift my notes around so I can see them. So that's the parenting plan document, which, as I said, would be used with a dissolution or just a petition for a parenting plan. I'm going to put that one away and take us back to the petition, because I want to also make a note when we get down, because this is a petition for dissolution, when we get down here, it talks about making a preliminary disclosure, serving the income and expense form with the MP 510, and doing the proposed property distribution with the form MP 500. And I just wanted to, again, quickly take a peek at those documents, which are under the heading Financial Documents. And we have the MP 500, which is fairly basic. Again, whose disclosure is it? Is it proposed? Is it amended? Did something get changed? It's got some warning about, hey, you've got to tell everybody what you've got. But one of the things that's different about it is it explains to people what we're talking about. So the section on real property says, hey, we're talking about land and buildings on the land, even if you only own a part of it, right? But it doesn't include a manufactured home unless that's been converted to an improvement on the land, and it explains that. Again, the same kind of thing with vehicles. Any trailer, mobile or manufactured home, is going to be in the vehicle category. We're guiding people, this is where you put it. And again, if we're talking about vehicles, we're also talking about cars, and there's a way to list additional vehicles. It's much like the additional children form, only it's for vehicles, MP 500B. Again, bank accounts, those kind of things. And not surprisingly, there's an MP 500C form if you have more than 3 accounts you need to list. And again, very much like the other forms we've looked at, if there's additional stuff, there's a form you can do. The additional accounts form, the MP 500C, is the default. If you've got more stuff, use that one form. Business interests, other assets, everything is going to be listed out here, except, and then expenses and liabilities, except for income and expenses, which takes us back to, make these smaller so that I can get back there, takes us back to that MP 510 income and expenses form that was mentioned. And again, warnings, got to choose whose it is, but then very basically, what income is there, what expenses are there, again, noting that you can use the additional forms to list additional accounts, additional expenses, or sources of income. I'll put that one away and get back to the petition. There's also even the option for a prenuptial agreement to be attached. Weren't we thinking? I really hope that doesn't come up very often. But there is a request for maintenance because we got input that people wanted it. I think it's probably one of those things that shouldn't be used. Pat had actually sent me a question about it prior to this training, and I said, it's on there because people wanted it on. I didn't say, I said we weren't going to really deal with it, but we didn't except for here, and it's on there because we got feedback that people wanted the option. So that takes us through the petition. I want to look at a few other forms real quick because, well, they're important and they're part of the process. The next thing I want to point out is the service documents and how those are set up, because they're set up a little bit differently. Oh, I guess I should pause. Before I do this, the question comes up, well, what if we want to do an interim parenting plan? Ask the judge to adopt our parenting plan until we get something more formal. And we're not going to go into them, but please realize that there are a motion to adopt a proposed parenting plan as an interim parenting plan, response, reply, and an order adopting the interim parenting plan if somebody wanted to do that. So those are there. Service documents. There are a couple of changes that are worth noting. One is the summons and temporary economic restraining order has some plain language explanations in it. Pardon me just a second. It explains a little bit standard kind of summons language here. Please note that it does reflect a 21-day service period, as is correct, unlike the current version of the forms that still say 20 days if you use the automated version. But basic summons language, but then an explanation of what the temporary economic restraining order means, what it does, because again, this is something that caused people to freak out. They would get the summons and temporary economic restraining order and see that phrase restraining order and freak out and not know what that meant. And so there's some plain language explanation that, hey, you can't mess with anything that's part of the marital estate, although it's much more plain language than what I just said. It's, it tells people they can use their property in the usual course of business, they can pay for necessities, but they're not allowed to transfer it or hide it, cash it out, cancel it, and they have to let the court know what they're doing with it. So a little bit nicer version of that form, or document rather. The other thing that is a significant change and is a little bit confusing to folks is the MP 401 form, which is called a request to sheriff to serve documents. The current version of the forms uses the Latin term for this, which is a precipe. So if you're looking at this and going, but wait, where's the precipe? The answer is we plain languaged away the precipe and instead called it the request for sheriff to serve documents because, well, that's what it is. In substance, it looks very much like the current version of the form, but it has a different title. So, where to find the respondent, what's being served, and then separate page for the record of service. What got served, when did it get served, where did it get served for the sheriff to sign off on. So same document, different name is really what I would say about that one. Also, when we look at the service documents, there are there's a bit of a difference with the notice and acknowledgement. Notice that there are two forms here, the notice and request for acknowledgement by certified mail, and then the acknowledgement of service by certified mail. So the notice and request says to the person, hey, I am sending you these documents, and please sign the acknowledgement, which is a separate document, but it includes some instructions, bullet form, easy to understand, what's going on here, what does this all mean, information, and there's actually 2 pages of this, and set up his questions. I don't want to have a sheriff serve me, what can I do? Fill out the acknowledgement, put it in an enclosed envelope and send it back within 21 days. What if I don't fill it out? Well, sheriff will serve you and you may have to pay the cost of doing that. And then some information on where the person can get help, and there's a certificate of mailing with it. I will tell you that the feedback that we got from the committee, the forms committee got, was that clerks didn't like having this information in there because they didn't want 2 extra pages. And we thought long and hard about this, but decided that it was important to put it in there, and the feedback that we got from folks other than clerks was this is actually very useful because it will encourage people to sign the acknowledgement and avoid that cost, avoid having the sheriff have to come and serve them. So let's take a quick look at that acknowledgement real quick. Acknowledgement of service by certified mail. I got the following documents. I understand that the date I received them was the date I was served, and then place to sign acknowledging. So pretty basic. Again, breaking it up, making it a little simple, and including some instructions within the form to make it easier for unrepresented folks to deal with what's happening. Okay, so we've now gotten through, I didn't close the wrong thing there. We've now gotten through getting somebody served. And I'll just point out, there's documents to request service by publication. There's also the documents for notifying CSCD. And again, the notice to person not named that we talked about before. All in here. But let's assume we've now gotten the person served one way or another, and they want to respond. What do? Well, they come and find a selection of responses. We're going to take a look at the response to the petition for dissolution with children, because that's the chunk of forms we're talking about. And this form is very, very much different from the current version of the response. Now, I will tell you the current version of the response is not going to go away because it's what somebody will have to use if they get served with a petition that is not one of these pro se forms. But if they get served with an MP 113 petition for dissolution with children, this form will be very nice for them because if we take a look at it and go through it, it exactly mirrors the petition. Section 1, jurisdiction. I admit that the court has jurisdiction over this case, or I deny the court has jurisdiction over this case because. Information about the petitioner. I admit it's correct, or it's not correct, here it is. The information about me is the respondent. It's either correct, or here's the correct information. Information about the marriage. It's either correct, or here's the right information. When did we separate? It's either correct, or here's the correct information. Same thing with pregnancy. And then we get down into the stuff about kids. I admit the list was right in the petition, or here's a correct list. The information about where the kids had lived, I admit that's right, or here's the correct information. And again, if they need more room, they're directed to the NP 113C, which is the form that lists additional children. So again, we're multi-purposing those attachment forms. Jurisdiction over the kids, opportunity to say something else about it. Other court cases, it's either correct or here's the right information. Other people, and again, here's direction to use the NP 407 for everybody that's listed here. But it's either they can also say admit or I deny it. And here's what's going on. Parenting plan. I admit the proposed parenting plan submitted by the petitioner is in the best interest of the children. It's a checkbox. Or I deny it's in the best interest and I'm submitting my own. But very, very similar. With the disclosure, I admit I got the disclosure. I deny I got the disclosure. Regardless of whether I got one from the petitioner, I'm sending the petitioner my own income and expense disclosure form. Same, we go through the property distribution. My point with this is that it exactly mirrors the petition. And so after someone has filled out this form, a judge or the parties could sit down with the petition and with the response and go down and see exactly what the issues in the case are going to be. There will be no question about what people disagree on, because they either will have checked the agree button or the agree checkbox, or they do not agree checkbox. And so it should be really easy to tell what the issues are. And again, there's space for other provisions, other things that somebody might want to ask for. You'll notice that both the petition and the response don't require notarization. They use the affirmation. I'm trying to remember what the right term for it is. But the thing that they swear under penalty of perjury that they're telling the truth. So we get the petition filed and served. We get the answer taken care of. And then the question is, well, okay, maybe we didn't get an answer. We want to do either we got an answer and we're ready to go to hearing, or we didn't get an answer and we're ready to go to default. We need documents for the hearing. There are documents for the hearing and decree. These are, again, there's a significant change here. Quick note, there's a link to the vital statistics reporting form and red lettering that says don't forget to do this, because in most jurisdictions you either won't get a hearing or you won't get the decree issued until you do that form. So the difference here, if you take a look at these list of forms real quick, one of the things that you'll see is that there isn't a request for entry of a default. And that is because, in the hopes of making things simpler, the MP 701 request for hearing includes the option of asking for a default. So, request for hearing. I'm the petitioner or the respondent or the co-petitioner asking for a hearing, and you have the option of saying, respondent did not appear, otherwise respond. More than 21 days has passed since respondent was served. Petitioner asks the clerk to enter default against the respondent. And in fact, there's a place for the clerk to do that at the bottom of this form, default entered or not entered. So the hope is that that will be simpler. But then the form goes on to say, did we deal with child support? Did we deal with the financial disclosure? We've waived it if we're asking for a default. However, it's going to be dealt with. And then the request for hearing is here as well. Schedule a default hearing, schedule an uncontested hearing, maybe that's not a default, or schedule a contested hearing. All in one form with request for hearing and entry of default together. And then there's a order form, and they can get their hearing set. And then one more time to look at the same sort of formatting, the decree matches to a large degree, matches what was in the, once we get through this initial information, matches how the petition was set up. So they kind of mirror each other, the petition, the response, and the decree. But again, designed to be used very quickly, checking the boxes, should be simple for the judges, we hope. But again, there's a reminder, I thought there was a reminder. Nope, I take that back. That was just in the petition. But a very simple document, and refers to parenting plan being attached, ready for the judge to sign. And then, of course, there's the notice of entry of decree, which we don't really need to take a look at, and other decrees. But that is what I would call a pretty darn quick overview of how the forms are set up to work, how people will be able to walk through them. And again, I really like this, what you have on your screen now, this graphical kind of representation of the steps and which forms to use, which is something that will be available for folks as well. Right now, the forms are for pilot use in Gallatin County and Cascade County. And once we've had some people try them and get some feedback, we'll be putting them out for general use. The remaining forms, the dissolution on its own, joint dissolution, and parenting plan on its own, joint parenting plan, are not quite ready because we don't have the instructions all set to go, although we have drafts of those that we're looking at. And there's some service documents that need to be finished up. It was a little bit of an oversight on our part that we weren't thinking that we were thinking we can use the same service documents for everything, but they are specific enough we need to change them. So we're going to be getting those put together shortly. So the forms are not ready to go for everything, but in terms of dissolution with kids, that setup is ready to go. So with that in mind, or with that said, we've got a couple minutes for questions, and I would be happy to answer questions.
So Ed, this is Pat. Can you hear me?
Yep.
On the responses, there's no service document, certificate of service. Do you still use the notice of acknowledgement? Or what do you use for a service document on the responses? Or they haven't been done yet?
Folks are gonna have to, the response does not include, I'm going to say this and then go, it doesn't, right? It doesn't include a certificate of or affidavit of service. I'm just checking to make sure I'm not lying. Yeah, so the folks are going to have to use a separate certificate of service when they do that. But one of the sets of instructions that we're working on is actually I believe is the response instructions that tells people you need to do that.
All right, so we'll just use the form that we have available.
Yeah, there's nothing wrong with the form, the certificate of service form that's out there, I don't think.
Okay.
So, good question though. And Linda said, and I think this is a great comment, I'm just looking at the things that people chatted me while I was talking, it would be helpful for folks to be directed to check with their local court for the fee waiver. And as you guys are probably aware, there are different judicial districts have slightly different versions of the fee waiver and slightly different procedures. And the instructions that I had up but accidentally closed, so I can't get back up real quick, do include instructions on getting the fee waiver form from the clerk. So yes, I think that's a great point, Linda. Thanks for reminding me that I should have mentioned it to people. Any other comments or questions?
Is this on or on? Mm-hmm. So Ed, I just want to say again that I do have some issues with the maintenance. Specifically, I understand that they can put their amount there, There's standards, of course, that we're not going to be involved in when those are determined. My concern is the perception that we're providing the courts that we assisted them in coming up with the amount, and the judges are going to say, well, what's the centers doing? Because that is, you know, a type of legal advice. I just want that voice.
Well, and
I think we really need to look into that.
And I will tell you that I agree. I happen to agree with you on that issue, but as we were developing the forums and looking at the feedback we got, I didn't win that argument. But I guess the reason I say that I agree with you on it is I totally, I get the point, and you know, obviously I have my own feelings on it. We did get a lot of feedback, and a chunk of it came from private attorneys that we should include that. And we did get some feedback from other folks too, saying, you know, people want to ask for this. We shouldn't ignore the fact that folks want to ask for it. And you know, my response to that when we were developing the forms is, look, we put in this other provision where people can put in whatever they want, and
right,
you know, if they really want maintenance, they can write it in the other provision. But again, that was my opinion didn't win out on that one. So you know, it's in there, and you know, it may be that when the forms are, when some people have had a chance to use them, and some more judges maybe see that and say, I don't want that in there, that'll come back to us, and maybe my argument will be more persuasive, and it'll come out. One other thing I do want to note for everybody about these forms is that unlike the current version of the forms that came out in paper and then years later were automated, automation of this version of the forms through what I think most people refer to as hot docs, which is, we're supposed to call it Law Help Interactive now. The automation process has already started. There's a developer who's currently working on automating this dissolution with kids form set. And what I have been told is that that automation person hopes to have an initial draft of the automation done by the end of June. So, you know, when that automation is actually ready for use is a horse of a different color. But you know, if you wanted me to make a guess, my guess would be that probably by the end of the year, the dissolution with children form set will be available in an automated form, and it's going to be automated slightly differently than the current version. When you look at the current version of the forms on the automated version, it's basically screens of questions, and you just see these questions, you type in your answers. And the automated version of these forms is going to be set up using an interface called A2J, which the A2J interface is a little bit hokey and cartoony, but it's basically a person standing next to a path that leads to the courthouse, and the questions come up in little dialogue bubbles, and then if you need more information, there's a place to click and get more information. But it's a little simpler, more user-friendly version of automation. It's still hot docs on the back end, but there'll be this A2J overlay, which should be easier for people to use. Rob, stop asking questions. How was the font chosen? I don't even remember. I think the committee just said, Arial, we're going to go with that. It is fairly easy to read. And yeah, Rob's Serif fonts are easier to read in body text. And I don't know that there's a lot of things that I could say to you. There was a long discussion in the forms committee about this particular issue. And I don't recall the committee having a long discussion about the actual font of the forms. So it is possible that we overlooked the science on that one. And I'm just going to have to go with, I apologize, because the developer would kill me if we wanted to change something like that right now. And I've never even talked to the developer. There's an intermediary between me and him. So we are about 5 minutes over time. Does anybody have any burning questions?
Ed, this is Kay. I just wanted to thank you for doing this. Thank you for training.
You're very welcome. And I will point out that I or another core member of the Forms Committee would be happy to do more training for anybody. So if there's folks that weren't able to attend, we can do another one. I have recorded this, so we can also make it available for people to watch the recording. We are happy to go over these when the rest of the forms are ready to come out. I imagine we can do some more training with those. When the guardianship forms are ready to come out, we can do some training with those as well. So the Forms Committee is happy to go through this with folks. They just have to ask. If anybody wants to contact me, I'm about to tell you what my email is. I'm also going to enter it in the chat box, and you can copy and paste it from there. But it's ehiggins, EHIGGINS, @mtlsa.org. And there it is in the chat box as well if you want to copy and paste it. So if anybody thinks questions later, you're more than welcome to contact me, and I'll do my best to get you an answer. Unless anybody has pressing questions right now, I'm going to stop the recording and end the meeting.
Great job, Ed. Thank you so much.
Thanks, Ed.
You're all.
Thank you.
You're all very.
Thank you, Ed.
Yep, you're welcome.
Thanks.